Hello, my name is Kaisa Crusco, and I am a family law attorney in Bedford, New Hampshire. This segment will focus on what to bring to your pretrial hearing. A pretrial hearing is a hearing that will be scheduled prior to the final hearing. Parties, counsel, and, if applicable, the GAL will be required to attend the hearing. It is a hearing where the court and the parties will get ready to schedule and conduct the final hearing. Court rules require that you bring to the hearing a pretrial statement, proposed orders that are applicable to your case, such as a divorce decree, a decree on a parenting petition, parenting plan, uniform support order, and child support guidelines worksheets, and also an updated financial affidavit. As always, these documents should be carefully and thoughtfully prepared. You may be limited to the issues that are raised in the documents. For example, if you do not list a witness, you may not be able to call that witness at the final trial. Similarly, if you do not raise as an issue the value of a certain piece of property, that may be off the table at the final trial. In order to help you prepare for the pretrial conference, you'll want to review Circuit Court Family Division Rule 2.21. This will help you get familiar with the things that you're going to be expected to discuss at the pretrial hearing. You'll also be required in your pretrial statement to list out all the issues listed in Rule 2.21. Like a proposed order in a divorce decree or a parenting plan, things must be set forth in specific numerical paragraphs that the court will then review. The first issue that the court will want to look at in your pretrial statement is a brief description of the issues that are disputed. This may be parenting time, this may be decision-making responsibilities, it could be alimony. You want to list a description of what issues still remain if there are anything that you have settled. The second paragraph will require you to list the property that is in dispute and the value of the properties and whether or not appraisals have been submitted. So these types of property will include real estate, pensions, bank accounts and investments, and personal property. If you have obtained an appraisal for a property, for example, real estate, you'll want to note that in the pretrial statement. The next paragraph is any special circumstances that would justify either an adjustment from the child support guidelines. So, for example, if you're looking for a deviation from the child support guidelines based on shared residential responsibility, based on high visitation expenses, if the parties live far apart and the visitation will require plane flights, and any other circumstances that would result in an adjustment from the child support guidelines, you'll want to note that here in your pretrial statement. If you're also looking for an award of sole decision-making responsibility, you'll want to note the circumstances that would require the court to award sole decision-making responsibilities. Similarly, an unequal property division. If this is not going to be an equal property division, if you're looking for something else than dividing the assets 50-50 or dividing the debts 50-50, you'll want to note those different circumstances here, and you can find those in the property division statute, RSA 458-16. Also, another special circumstance would be alimony, so you'll want to note the reasons why there should be an award of alimony. The next paragraph 4 requires you to list any expert witnesses. You'll want to make sure that you have made your expert disclosures and also list your expert witnesses here. Different types of expert witnesses may be a real estate appraiser, maybe a financial or a tax advisor, maybe a therapist or a mental health professional. After you list the expert witnesses, you'll be required to list any other witnesses. You'll want to make sure that you are inclusive of anybody that you reasonably may call as a witness. Then the court will also want to hear whether there are any pending motions that need to be addressed, either pre-trial or could be heard at the time of the trial. For example, if there is a pending motion for contempt, that may not need to be heard before the actual final trial. That could possibly be heard within the trial itself. However, if there are motions to exclude certain evidence, the court will want to know that so that a hearing can be scheduled either before the trial or that issue can be heard at the start of the trial. The court will also want to know if there are any unresolved discovery issues. Have the parties exchanged their Rule 1.25a discovery? Have interrogatories been answered? Are there depositions that are outstanding? Do the parties disagree about any discovery that needs to be exchanged? And then the court can take other steps after hearing those issues in order to help resolve the discovery issues. The court will also want to know what both parties and counsel believe the length of trial may be. This is always a sticky issue. You don't want to overestimate the amount of time that a trial may take because the longer you need, if you need a 4-day trial, that trial is going to be much farther out than it will take to get a 1-day trial. At the same time, though, you don't want to underestimate the amount of trial time that you need because if you do not finish within the amount of time that you're allotted from the pretrial hearing, then you could either be stuck with that amount of time and not have been able to fully present your case, or at the end of that, the amount of time that the trial was set for, you could have another hearing date which is months out, even as far as 6 months out until you are able to get your next trial time in order to conclude the trial, and that's difficult for everybody. After the length of trial, the court will want to hear what the status of settlement negotiations are. Have you gone to mediation? When you went to mediation, did you only discuss temporary issues? Would it be helpful to go to mediation to discuss any kind of final issues that are for the trial where you could narrow down the issues? And then the court, if you haven't been to mediation, the court will usually order you to go to mediation unless you have a really good reason why not, such as domestic violence. The next paragraph will look at the special circumstances that may affect the trial. This could include conflict dates from the guardian ad litem or from the attorneys. It could also include if you have a pre-planned vacation that has been scheduled very far in advance. You'll want to make sure that the court has the conflict dates so that the trial is not scheduled during a time that people are unavailable. The court might also look to the availability of witnesses. Are there witnesses who are out of state that would need to travel? Are there expert witnesses who have their own schedules and conflict dates which would need to be taken into consideration? The last paragraph asks whether or not a record of the trial is requested, and you will certainly always want to have a record made of the trial in the event that there would be an appeal. At the hearing, the court will fill in a pretrial conference report, and that will become a court order. This will usually review the same issues that we just discussed, and the court will complete its own pretrial conference report just as you submitted a pretrial statement. The court will note various issues such as disagreements or agreements about property values, length of trial, and attendance at mediation. So you'll want to make sure that the information the court has when completing this pretrial conference report is accurate and notes your position on the various matters. If you have any questions about pretrial conferences, please feel free to contact my office for further information. Thank you.